So far, we haven't heard back on if she's going to make a ruling regarding this delaying of permits.
U.S. lawmakers passed the most significant federal gun restrictions in decades on Friday, following years of false starts and failures to tighten gun laws.
Because law enforcement agencies simply just aren't ready for it yet. Measure 114 is set to take effect on Thursday.
Gun violence is the greatest. In the case of the Parkland shooter,
90% of the, mass shootings would have been prevented. Even if they do that, it would have been prevented.
Patrick David in his videos put out gun control solutions believing that these could solve the ongoing U.S. problems. Measure 114 will be tested in federal court. Beginning of the legal proceeding to determine if Oregon's Measure 114, which restricts access to firearms, satisfies constitutional requirements. A criminal background check must be completed before any gun sales or transfers, and more than 10-round mags cannot be sold, transferred, or manufactured under Measure 114. It also requires a permit for gun purchases. The topic of whether the Second Amendment maintains the in-question gun control regulations will be the main subject of the 5-day trial. According to lawyer Daniel Nichols, who is defending the Oregon Firearms Federation, Oregon State Shooting Association, the National Shooting Sports Foundation, several rural sheriffs, and others, the case involves the right to bear arms under the Second Amendment, the freedom from taking property without just compensation, and the right to understand the law. The state and the statute refer to what Nichols and other witnesses for the pro-gun rights organizations dubbed large-capacity mags, which are currently in widespread use. They stress that more than 100 million people had lawfully purchased mags with more than 10 rounds since 1990 for use in self-defense. State attorneys disagreed, claiming that it's extremely uncommon for a self-defense scenario to call for shooting more than 10 rounds, and that mags aren't technically considered to be weapons, but rather firearms accessories. Instead, according to the witnesses they want to call, large-capacity mags are regularly used in mass slayings and can be limited because of the extra harm they cause.
Congress passes most significant gun reform bill in decades, sends it to Biden. CNBC Stories.
So far, we haven't heard back on if she's going to make a ruling regarding this delaying of permits.
Brad Lowry, the sheriff of Sherman County and one of the listed plaintiffs, said he still wants to be able to use large-capacity mags to protect his family after retiring. He also supports allowing the 1,900 people of Sherman County, who are under his and 6 other deputies' protection, the freedom to purchase whatever firearm they want. Customers interested in self-defense, according to Jessica Harris, the operational manager of the G4 Archery Outdoor Store in North Plains, buy things with as many rounds as possible. If Measure 114 passes into law, her store would be forced to liquidate its current mags, which would cause a sharp fall in revenue. The following inquiries have been made to U.S. District Judge Karen J. Immergut, who in December declined to halt the new Oregon limits before a state judge suspended them in another case. Questions about the permit-to-purchase program in Oregon. Is Oregon's permit-to-purchase system regarded as a shall-issue licensing practice consistent with the history of gun control? Or does it infringe on people's due process rights by barring them from exercising a fundamental constitutional right? The U.S. Supreme Court's ruling in a New York case last summer served as the foundation for this inquiry. The New York Supreme Court struck down a law that placed rigorous limitations on carrying a gun outside the house. The ruling urged lower courts to evaluate constitutional rights violations of gun control statutes using new text and history standards. The Second Amendment's plain language protections for the plaintiff's desired behavior must be considered by the courts, and if they are, they must also determine whether the regulation is consistent with the lengthy history of gun control in the country. During a live-streamed news conference last week, Brady United's chief legal officer, Douglas N. Letter, stated that a number of issues addressing gun-related bans remain unanswered as a result of the ruling. In his deposition on behalf of the plaintiffs, Mark Hanisch, a competitive shooter who has worked as a sales executive for several firearms manufacturers and who is currently vice president of sales for the Arizona-based Timney Triggers mag manufacturer, stated that mags holding more than 10 rounds are typical.
U.S. lawmakers passed the most significant federal gun restrictions in decades on Friday, following years of false starts and failures to tighten gun laws.
Implementation of Oregon's new landmark gun control measure, a federal judge could delay the permit requirement.
Hanisch admitted to holding ammo Inc. stock for over $1 million and has over 18 years of experience working for companies that advertise large-capacity mags. Images of 14 stacked Surefire mags, either 60 or 100 rounders, that were discovered in the hotel room of the assassin in the greatest mass murder in American history, the October 1, 2017 Las Vegas shooting, were displayed to Hanish by Senior Assistant Attorney General Brian S. Marshall. He stated during his testimony that he supported the selling of 100-round mags to consumers. Attorney for the Gun Safety Alliance, Scott Farron, visited the Surefire website, which has commercials for high-capacity mags, as well as other gun accessories. Hanish stated that it is appropriate for Surefire to provide people with high-capacity mags, since it provides them the advantage in self-defense. According to Ashley Hlebinski, a former curator in charge of the Cody Firearms Museum and senior fellow for the new Firearms Research Center at the University of Wyoming College of Law, the $12,000 raised from the sale will be used for self-hurt prevention. She also acknowledged consulting work she did in 2017 for Daniel Defense, the maker of the AR-15 rifle that was used in the May 2022 massacre at the elementary school in Uvalde, Texas, which claimed the lives of 19 students, 2 teachers, and 17 other persons. Impact of high-capacity mags. One of the many experts the plaintiffs called was Mark Hanish, a veteran of the firearms industry and the present vice president of sales for Timney Triggers, a company based in Arizona that produces replacement triggers for rifles and handguns. Along with being a successful competitive shooter, he has also worked in sales for FN America, a branch of the Belgian company Fabrique Nationale that produces firearms for the American public and military. Hanish was compensated by the plaintiffs to make a speech on semi-auto guns and detachable mags that hold more than 10 rounds of ammo. Hanish asserts in his declaration that nearly every handgun and rifle line available at FN America when he was there was sold with large-capacity mags. Brian Marshall, Senior Assistant Attorney General for the Oregon Department of Justice, questioned Mark Hanish during cross-examination over his prior position as Vice President for Marketing and Sales at Surefire, a business well known for making mags that can store up to 100 rounds. Hanish worked at Surefire from 2016 until 2018, according to his LinkedIn profile.
A political battle where it should be a moral battle, in my opinion. We have the right to defend ourselves.
For gun purchases by 2 months, it is part of Measure 114, which voters passed in November.
The sad incident that happened on October 1, 2017, when a lone shooter fired into a music festival crowd from a suite on the 32nd level of the Mandalay Bay Casino, was referred to as the Las Vegas shooting, and Marshall questioned Hanish if he was familiar with the term. The shooting left many people injured and resulted in the deaths of 60 individuals. Marshall showed Hanish pictures of large-capacity mags discovered in the Slayer's hotel room and asked if they looked like Surefire mags. Hanish retorted that he couldn't tell from the images what the exact capacity of the mags was, and that there was no obvious sign that they had been put to use. Hanish concurred that the images seemed to be Surefire 100-round mags after Marshall showed a succession of images of AR-15 style guns and lengthy mags found in the shooter's room. Then Marshall asked, "Do you think it's likely that Surefire 100-round mags were used in the deadliest shooting in American history?" Hanish answered, "From those pictures, yes." Oregon's gun laws are upheld by a federal judge. Judge Karen Immergut of the U.S. District Court has ruled that the new gun safety regulations in Oregon, which were adopted by voters last autumn, are constitutional. In accordance with the nation's history and tradition of restricting particularly harmful features of weapons and firearms to ensure public safety, the order ruled that banning large-capacity mags and requiring a license to purchase a handgun are appropriate measures. The decision was made during a trial that lasted a week in early June to determine if Oregon's new gun restrictions, which voters adopted last autumn, were constitutional. The conservative majority on the Supreme Court determined that no one should require special authorization to exercise their freedom to carry a firearm outside of their home under the Second Amendment. Since they are rarely used for self-defense, large-capacity mags are not covered under the Second Amendment. The Second Amendment also gives governments the power to restrict gun ownership to law-abiding, responsible citizens. Voters approved Measure 114 by a margin of 50.6% in November, and since then, gun rights organizations, sheriffs, and store owners have filed lawsuits to overturn the decision. a state court judge halted the law's implementation in January. The bill would prohibit the sale of so-called large-capacity mags in the future that can hold more than 10 rounds of ammunition and would call for a permission to be obtained in order to purchase a handgun. Candidates for permits will need to finish a safety course and a federal background check. The law's mag limitation provision received practically all of the attention throughout the federal trial.
Criminals will always find guns.
Absolutely.
And it is the cities with the most restrictive gun policies in the country.
Because law enforcement agencies simply just aren't ready for it yet. Measure 114 is set to take effect on Thursday.
Regulating mag capacity, according to the plaintiffs, violates the Second Amendment's guarantees of freedom. Attorneys cited the New York State Rifle and Pistol Association versus Bruin decision of the Supreme Court, which held that lower courts can no longer evaluate whether a statute prohibiting firearms serves public objectives, such as promoting public safety. Gun control laws must also be consistent with this nation's historical tradition of firearm regulation, according to the Bruin decision of the Supreme Court. Legal actions against Measure 114 in Oregon. As a result of Measure 114, numerous lawsuits have been brought against the state of Oregon. The Arnold B. Brown lawsuit, which was filed in state court by the governors of America and Goa, is one of these cases. A number of federal court proceedings were also started, and they were ultimately combined under the supervision of one judge. This merged group's lead case is still ongoing. Measure 114 imposes a ban on the future sale, acquisition, and transfer of firearms that the state deems to have a significant capacity, in addition to introducing a permit-to-buy requirement. Despite the fact that the law does not make it illegal to own a firearm, buying a new handgun requires a license. Numerous lawsuits were brought against the state of Oregon to stop Measure 114 from going into effect as a result of implementation issues. The Arnold B. Brown state lawsuit and other connected federal cases are among these legal actions. They will be the main topics of our discussion here. The permitting system's initial rollout was temporarily halted for 30 days by an Oregon federal court judge. The restriction on mags, however, was permitted to take effect right away. Judge Robert Rocchio of the Harney County Circuit Court concurrently issued an unequivocal temporary restraining order in the Arnold state action. This TRO effectively stopped the implementation of both the permitting system and the mag ban. The state court then convened a hearing on a motion for a preliminary injunction. Judge Rocchio maintained his directive to halt the permanent plan temporarily during this hearing. He said that his order would be in place until Oregon's state government gave notice that their new permit system could be effectively implemented. A preliminary injunction was also granted against the state's mag prohibition by Judge Rocchio's decree. There were still active federal lawsuits awaiting resolution as these proceedings in the state court continued. The outcome of these federal cases remained to hang over Oregon's implementation of its gun laws. Defending in federal court Oregon's gun laws. The permitting system and Oregon's ban on handguns have both been upheld by the federal court judge after an accelerated hearing. The judge summarized the case by focusing on two important issues. She decided that both questions had been satisfactorily answered during a week-long bench trial. 1. Is it legal for Oregon to limit the number of rounds law-abiding persons can carry before having to reload? 2. Is it possible for the state of Oregon to mandate that people who buy firearms receive a permit that involves a background check, safety instruction, and assessment of their mental health?
Gun violence is the greatest. In the case of the Parkland shooter,
if the judge agrees to the postponement, then starting in February, anyone who purchases a gun in Oregon will be required to have a permit.
They gave him psychotropic drugs, and they put him back out on the street, and he killed people.
The judge argued that mags with more rounds than 10 do not provide the same level of safety and are not acceptable for self-defense. Given this, she is in favor of the mag restriction. The Supreme Court has specifically recognized self-defense as the foundation of the Second Amendment right in its case law, despite the possibility that alternative uses of firearms are legal. Although not expressly protected by the Constitution, hunting and the recreational use of firearms are also not outright forbidden. The court underlines the legitimacy of the state's rules while acknowledging that there may be legal justifications for handgun usage other than self-defense. A more limited interpretation of the Second Amendment. with the justification that it safeguards a person's right to possess a widely used firearm solely for self-defense. The court in this decision has taken the action of narrowing the Second Amendment's purview. The judge took action in this regard. This judgment is seen as a continuation of lower courts' efforts to misapply and limit Supreme Court rulings. Additionally, the court wants to place limitations on how the phrase common use for lawful purposes, which was used in the Heller and Bruin cases, can be understood. According to her, it should signify that the pistol in question is often used for self-defense, as opposed to only being utilized on occasion. Similar actions were done by lower courts after the Heller decision, where certain circuit courts acted to limit the verdict's scope. The Second Amendment's language and the Supreme Court's precedent are in accordance with this viewpoint, which the judge disapproves of despite it being in line with both. She disagrees with this view, nevertheless, on the other hand. The vast majority of firearms and attachments in the nation would pass that test if it were only necessary to show that the user's subjective intent was to employ the weapon or accessory primarily for legal purposes, particularly for self-defense. As an alternative, the judge makes the case that common ownership should be the criterion that is applied, which is similar to the strategy the Supreme Court utilized in the Cayetano case. The Supreme Court reached the decision in that case that the widespread ownership of 32,000 stun guns across the nation established their protection under the Second Amendment due to the frequent legal use of these weapons. Arguments against and possible results. The issues with the judge's decision in this case are numerous, but it would be impossible to list them all. In addition to departing from previously established norms and being contradictory with itself, the judgment also presents the facts in a false light. The court, for example, fails to honor the Second Amendment's wording, custom, and history in the Heller case by incorrectly applying the Bruin precedent. In light of the case, this is understandable. The judge's view on the Cayetano case is one element that prompts some skepticism. In it, she falsely claims that the test entails the use of 35,000 stun guns in actual self-defense, which raises some questions. The judge's objectives and her judgments regarding the case are completely altered by this miscommunication. On the plus side, Judge Raccio's decision to give a preliminary injunction against the mag ban in the Arnold State Court lawsuit is encouraging. Taking on the Oregon restrictions may now be possible given this. The Oregon case just went through a summary judgment hearing, and a full trial is slated to begin in early September. Given his prior propensity, it is predicted that Judge Raccio will grant the summary judgment in the plaintiff's favor. The state of Oregon is not anticipated to suffer an immediate negative effect from this ruling because the TRO is still in force. Seeking practical solutions. Patrick David's perspective on gun control underscores the complexity of the issue. He stresses that it transcends political affiliations, highlighting its importance as a genuine American concern. He draws parallels from the regulated financial industry to propose measures that could enhance gun safety. However, his admission that regulations won't eliminate all crime raises questions about the efficacy of these proposed solutions. Patrick recounts a personal anecdote from his youth about obtaining a firearm illegally. This serves as a reminder that criminals can circumvent laws to acquire weapons. He emphasizes that advocating for stricter regulations should not lead to complacency about crime prevention. It's worth questioning whether additional regulations primarily affect law-abiding citizens rather than criminals who won't adhere to such measures.
We still got some of them, their guns that got it illegally, or some of them that got it. Even the kid who got it, he wasn't on any kind of medication.
My executive manager is attempting to compel me to participate in an activity which placed public safety at risk.
Patrick's focus on background checks, training, education, and precautionary measures as potential reforms suggests a willingness to engage constructively. These areas of reform align with enhancing firearm safety. However, it's essential to examine the practical implications and potential limitations of these proposals. Patrick references gun-related statistics from an older CDC report. While he cites the numbers of deaths due to firearms, he correctly points out that a significant portion of these are attributed to suicides. The data underscores the complexity of the issue and highlights the importance of addressing mental health concerns alongside gun control measures. Patrick David's advocacy for enhanced background checks and waiting periods forms the core of his proposed gun control measures. However, these suggestions warrant scrutiny. especially in light of their practicality and potential impact on Second Amendment rights. Patrick alludes to background checks in the insurance industry as a model for comprehensive firearm checks. He particularly emphasizes the potential inclusion of prescription checks. This concept, though novel, raises concerns about infringing on personal medical privacy. Allowing the government to access an individual's prescription history for the purpose of determining gun ownership eligibility is a significant invasion of privacy and opens the doors to broader government surveillance. Patrick contends that waiting periods could be instrumental in preventing impulsive actions leading to suicides. He cites statistics suggesting that states with waiting period laws experience lower suicide rates. While addressing suicide is crucial, the effectiveness of waiting periods in curbing such incidents is debatable. Addressing mental health concerns and improving access to mental health resources might be more effective approaches to suicide prevention. Patrick's proposed reforms touch on critical questions about balancing individual rights and public safety. While his intentions to reduce gun-related harm are commendable, the solutions presented raise concerns about government overreach and the erosion of constitutional rights. Striking the right balance between protecting the public and preserving individual liberties remains a challenge. Mandatory training and licensing. The fundamental difference between firearm ownership and activities like driving is that gun ownership is a constitutionally protected right explicitly enumerated in the Second Amendment, while driver's licenses and other licenses are for privileges granted by the government. The right to keep and bear arms is a pre-existing right that the government is constitutionally barred from infringing upon.
Photo ID, fingerprints, firearms training, a background check, and a permit issued by police to buy a gun.
I agree with what he said. I think there has to be a greater emphasis on mental health. Guns don't kill people. People kill people.
Individuals should have the freedom to choose whether or not to undergo training, while also bearing the responsibility for their actions. While the idea of enhancing safety through mandatory training and licensing is appealing on the surface, its implementation within the context of Second Amendment rights requires careful consideration. Balancing public safety with individual rights necessitates a nuanced approach that avoids unnecessary infringement while addressing legitimate concerns. The ongoing debate surrounding gun control and Second Amendment rights should continue to engage with these complexities to find effective and balanced solutions. Universal background checks. While this might seem like a reasonable measure to prevent guns from falling into the wrong hands, there are important considerations to keep in mind when discussing universal background checks within the context of Second Amendment rights. The concern about private sales, where individuals exchange firearms without undergoing background checks, is rooted in addressing potential gaps in the current system. Advocates of Second Amendment rights argue that requiring background checks for private sales could create unnecessary bureaucratic hurdles and potentially discourage lawful firearm transactions. The practical implementation of universal background checks also presents challenges. Creating a system for background checks on private sales would require a comprehensive infrastructure, potentially involving federal databases and additional paperwork. This raises concerns about data security and potential government overreach. The discussion around universal background checks reflects the ongoing debate between public safety and individual rights. While enhancing background checks may help prevent some illicit firearm transactions, it's essential to approach this issue carefully within the framework of the Second Amendment. Any measures should be designed to both ensure public safety and uphold the rights of law-abiding citizens. As the debate continues, finding common ground that respects both perspectives remains a complex challenge. Age restrictions and advocacy for gun control. The discussion around age restrictions for purchasing firearms is a complex issue that intersects with cultural, legal, and constitutional considerations. Patrick David raises the question of why the age to purchase firearms is lower than the age for alcohol consumption, expressing his belief that the age to purchase firearms should be raised to 21, in line with the age for purchasing alcohol. It's worth noting that the legal age for purchasing alcohol and firearms varies due to different societal and historical contexts.
Both Oregon's Attorney General and the Department of Justice asked the state Supreme Court to overturn that ruling.
90% of the, mass shootings would have been prevented. Even if they do that, it would have been prevented.
While the idea of responsible firearm education is valuable, mandatory requirements could potentially place undue burdens on individuals and create barriers to exercising Second Amendment rights. Ultimately, discussions about age restrictions and other gun control measures require a nuanced understanding of constitutional rights, historical context, and the broader societal challenges surrounding firearms. Striking the right balance between preserving individual liberties and ensuring public safety remains a key consideration in any policy debate. That's all for this video, folks. See you next time.